Me over again lots of time. And so, thank you, ladies and gentlemen, for being here. Welcome back to our full meeting of our Standing Committee on Justice and Human Rights. It's meeting number 59, and we are televised today. And pursuant to order of reference of Monday, November 24th, 2014, we're going to discuss Bill C-26 this afternoon, an act to amend the Criminal Code and the Canada Evidence Act and the Sex Offender Information Registration Act to enact the High-Risk Child Sex Offender Database Act and to amend consequential amendments to those acts. Ladies and gentlemen, just so you know, we have two ministers with us. We have Minister of Justice, Minister MacKay, and the Minister of Public Safety, Minister Blaney. They're both going to give opening statements, and then we're going to go to discussion rounds. And then before we go to the second hour with the officials, we're going to talk about the agenda that was we need approval for the committee on subcommittee on agenda, which we'll discuss the rest of the meetings we'll have on this particular topic. But without further ado, I want to call on the Minister of Justice, Minister MacKay, to opening remarks. Thank you, Minister.
Thank you very much, Chair. Colleagues, pleased to be before you here at the Justice Committee to discuss Bill C-26, the Tougher Penalties for Child Predators Act. This is my 51st appearance before committee. This particular bill, as you know, and its proposed amendments seek to ensure that child sexual offenders are held accountable for the horrific crimes they commit against the most vulnerable and valuable members of our society, mainly children. This bill proposes to achieve this important goal through a range of different measures. Mr. Speaker, Mr. Chair, what we're attempting to do here, of course, is bring forward legislation that further supports our government's effort to protect vulnerable members of society. Ce projet de loi propose de cette.
This bill seeks to fulfill that objective by a variety of measures, namely by amending the Criminal Code and the Act, the Sex Offender Information Registration Act, and the enactment of a high-risk child sex offender database.
And officials, as well as Minister of Public Safety, Stephen Blaney, who shares responsibility for this particular legislation, but in particular the amendments that will result in a new database, and I'll let Minister Blaney speak to those sections of this bill. The objective, though, to be clear, is one that all parliamentarians should support. This is clearly a very non-partisan issue. Yet some have questioned the necessity for the proposed amendments before us, and I want to address some of those questions. These amendments are necessary because of the sad reality that the instance of child sexual offences continues to rise. In 2013, police reported sexual offending against children had actually increased again, this time by 6%. In 2012, 2011, each calendar year saw a 3% increase. As Statistics Canada noted, sexual violations against children was one of the few categories of violent offences in Canada to increase in 2013. So this is coming from Jurastats 2013, which was released in July of this past year. These numbers, we can all agree, are cause for concern. We feel compelled to reinforce our response to these serious crimes, and I believe Canadians share these concerns. Bill C-26 better reflects the seriousness of child sexual offences by proposing to increase mandatory minimum penalties and maximum penalties for many child sexual offences. For example, this bill would ensure that maximum punishment for all hybrid sexual offences against children would be 2 years less a day for a summary conviction and 14 years on indictment. In addition to increasing the penalties for making and distributing child pornography, Bill C-26 proposes to make these offences strictly indictable to better reflect their severity. Child pornography offences have devastating and long-lasting impact on victims, particularly those that are posted on the Internet, where they can reside for someone's lifetime. And we have seen in particular how this intersects with the cyber legislation and how often these types of images are used to bully young people in particular to a point where they take their own lives. Chair, colleagues, this bill would also ensure that it would be considered an aggravating factor to commit an offense while subject to conditional sentence, order, parole, or statutory release. These are long overdue changes that will assist in preventing future offenses by known or suspected child sexual offenders. Bill C-26 proposes higher penalties for those convicted of breaching supervision orders. It's our belief and our responsibility that to ensure that supervision orders imposed on these offenders, once released in the community, are actually observed, and that breaches of conditions imposed to protect children result in serious consequences. So the type of conditions, as we know, are that there be no contact, that a person stay away from a certain household, that there be certain conditions around possession of weapons or alcohol or drugs. Those are the type of conditions, Mr. Chair, that often, if breached, can and often do result in further offenses. So to achieve that objective, Bill C-26 proposes to increase the maximum penalties for breaches of prohibition orders under Section 161, probation orders found in Section 733.1, and peace bonds, Sections 810 to 810.2. And these types of orders often contain conditions intended to protect children that I referenced earlier. Maximum penalties for breaches of conditions of any of these orders would be increased from 6 to 18 months if preceded by summary conviction, and from 2 to 4 years if preceded by indictment. Mr. Chair, our government is also committed to ending what are sometimes called sentence discounts for child sex offenses. That is to ensure that we recognize each and every child and the offense that has affected their life. To that end, C-26 requires courts to order in all cases that sentences imposed for child pornography offenses are served consecutively to sentences imposed for other child sex offenses. This bill would also ensure that offenders who sexually abuse multiple children do not receive sentence discounts just because the sentences are at the same time for the offenses involving multiple victims. Further, Mr. Chair, Bill C-26 would clarify the text found of subsection 718.3 sub 4 of the Criminal Code, which contains the general rules regarding concurrent and consecutive sentences. Its current wording is the result of an amalgamation of rules that predate Confederation, and as such requires clarification and modification, so we take this opportunity to do so. Le projet de loi C-26
Bill C-26 also proposes to codify certain applicable rules to indictment and sentencing, consecutive and concurrent. As a concurrent sentence would be a indictable offense to commit sexual infractions against several victims.
Should be imposed in certain circumstances, even if the offense in question were committed as part of the same series of events or events. And so this bill would recognize two of these circumstances. An offense committed while fleeing a police officer would be served consecutively to any other sentence arising out of the same series of events, and a sentence imposed for an offense committed while on bail should also be served consecutively to other sentences imposed. And so there is precedent to proceed in this fashion. Mr. Chair, C-26 will also amend the Canada Evidence Act to ensure that spouses of individuals accused of child pornography offences are compellable witnesses for the Crown. The testimony of an accused spouse may be required to prove guilt beyond a reasonable doubt, for example, where child pornography is found on a home computer. In conclusion, and just before I turn it over to Minister Blaney, Mr. Chair, colleagues, our government recognizes that criminal legislation alone is an incomplete response to child sexual abuse, and the criminal justice system's response to sexual violations against children must be multi-pronged or holistic. This bill, C-26, forms an integral part of the overall response. But I'm particularly pleased that our government has allocated over $10 million for now 21 new or enhanced child advocacy centres to address the needs of child and youth victims of crime. And I visited a number of these centres, as I'm sure many of this committee have, to see how these centres and these programs are assisting in the recovery of victims, young victims in particular, who have in many cases undergone considerable trauma as a result of sexual offences. So that is just another example of the overall response that we're taking as a government. I commend all of those in particular who are working with young victims and the special needs that they require. And so with that, I'll turn it over to Minister Blaney. Thank you.
Minister. Mr. Blaney, the floor is yours.
Absolutely. Thank you, Chair Wallace. Alors, je vous remercie, Monsieur le Président et membres du...
Thank you, Mr. Chair, and the members of this committee to have me here today. I'm very happy to be with my colleague today, Minister of Justice and Attorney General for Canada, the Honourable Peter MacKay, to speak to you about the portion of this bill that has to do with public safety. This bill that we know as the sex offender bill. We want to protect children from pedophiles. It's as simple as that.
Children from sexual exploitation and abuse. As Minister MacKay indicated, while violent crime rates in Canada are trending downward, sexual violations against children were on the rise. Police reported some 4,200 incidents of sexual violations against children in 2013. Les Canadiens sont légitimement
Canadians are legitimately concerned by the mobility and the behavior of sexual offenders who leave this country and commit crimes overseas. That is why, in order to deal with these most troubling questions, we have suggested this bill known as the increasing penalties for sexual offenders, especially in the case of sexual offenders who have been sentenced for sexual offenses committed overseas against children from other countries.
I will discuss the components of the bill that will give law enforcement better tools to crack down on these despicable individuals, which is traveling data, the database in itself, and also the information, sharing of information between CBSA and the RCMP. Alors, nous avons déjà proposé d'importants changements.
We have already suggested major changes, for example, to the high-risk child sex offender, or rather the Sex Offender Information Registration Act that gave birth to the National Sex Offender Database. Our police officers use this National Sex Offenders Database that is managed by the RCMP in order to help prevent sexual-based crimes and to furnish investigations.
Accessible at this time to law enforcement, where there are 36,000 sex offenders. Of these, nearly 25,000 have committed crimes, acts against child. À l'heure actuelle, de nature...
Currently, all sex offenders that are registered have to declare once a year, and every time they change their address, their name, their employment, or any volunteer activities, they are also obligated to declare any absences from the country for 7 days or more. However, in the case of international travel, they are only obligated to declare if they're going to be outside of the country for 7 days or more and give the approximate dates of their travel. There are no obligations to provide the name of the destination. That has to change, and that's why we have put in place the legal measures in this bill. Why are we doing this? Because we have to do more to protect our children from sexual exploitation, a job that starts here, but it's a responsibility as well that is extended to all children across the world.
Predators Act is important because if adopted, it will better protect children against people who want to steal their innocence for their own perverse sexual gratification, and it would hold those who commit these heinous crimes accountable for the harm they inflict on society. Si on prend, par exemple, un délinquant sexuel qui...
If you take a sexual offender that's known, that lives in Ontario, wants to travel to British Columbia for 2 weeks, he has to provide the coordinates of where he's going. But if he's leaving for 2 weeks, there are no rules obligating him to do anything. That is if he travels internationally.
this practice would end. The sex offender would have to provide travel details for trips outside Canada lasting 7 or more days and provide the precise dates of departure and return. Unfortunately, sexual tourism exists. It is important to address this practice when it affects children and when it affects Canada. De même, un autre changement clé, et c'est le deuxième.
Another key change, the second one, will help the information exchange between police officers and the CBSA. Given that the CBSA is not considered as a police force, the current act does not allow them to, does not allow us to give information from the National Sex Offender Registry to the CBSA, and the measure that we've introduced in this bill will change that. Furthermore, the CBSA will have the authority to collect information about the travels of sexual offenders and to transmit them to the people who manage that database. So you'll see more of that information exchange going both ways. Considering the important role played by the RCMP and the CBSA in order to protect Canadians' public safety, the fact that we are now allowing this information exchange is a key part of this bill. It will reinforce current acts and laws and will make the sex offenders who travel accountable.
A measure which Canadian feels very concerned about, and as a father as well, and that is the right of victims, children, and families to know whether there is a high-risk sex offender living in their neighborhood. And I insist, high-risk sex offender living in their neighborhood. Canadians have the right to know the character of the individuals who are near their children. If a dangerous pedophile is within arm's reach of their child, they have the right to take proper actions and precautions. That is why the bill would enact the High-Risk Child Sex Offender Database Act, which would allow our government to create a national public database. This bill will create a public registry of high-risk sex offenders so that parents can take responsible measures to keep their children safe. I was pleased to see nearly all party support for this important legislation, save for the Green Party, who voted against it. I hope that members of the committee will support our plan to make sex offenders more accountable, to better protect children in Canada and abroad from sexual exploitation, and to give Canadian families access to information that will help them keep their children safe. The tougher penalties for child predators act just that. Thank you, Mr. Chair.
Thank you very much. Thank you, ministers, for your opening statements. We'll now go to rounds of questions, and our first question from the New Democratic Party is Madame Beauvais.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, ministers, for here with us. Mr. Riquet, you say this was your 51st time before this committee, and Mr. Blaney, it's your first time before us. I hope that you're going to give us the time to properly study Bill C-26. So we were very happy to send it to committee for study. But I imagine that you're going to give the time that the committee needs in order to study the impact of it, because it's a big issue and it requires the presence of 2 ministers here at this committee, which means that there are major ramifications in all sorts of ways. And far be it from me to think that you want us to do a quick ended study of this. You probably expect us to do a serious study and move with diligence.
Both ministers.
Mr. Chair, Madame Boivin, as you would know, ministers do not interfere in the business of committees. We do not direct the timings or the witnesses or
Glad to hear.
the length of time that you'll have to study this bill. But certainly, je suis complètement d'accord avec.
I completely agree with your question. This is such a major bill with all these major ramifications for our justice system. We are very confident that you'll take the time that you need.
Bill. Depuis 2006, votre gouvernement conservateur
Since 2006, your conservative government has already adopted a whole slew of measures to protect children. You've put in place the Safer Communities Act. You have the new mandatory minimum sentences for already a set of offenses against children, including sexual aggression, armed sexual assault. You've also prevented from anybody you've also made it impossible, harder for people to give sexually explicit activity, sexually explicit material to children, to incite sexual activity with children. You moved it from 14 to 16 years, the legal age for sexual consent in Canada. You've put in a legal measure to obligate ISPs to declare child pornography, and yet 9 years later, after this slew of measures, you're telling us today that there's a 6% increase in sexual-based offenses against children. Is C-26 an admission that your approach in all this has failed? And also, if that's not the case, what studies have you based this study on? How did you analyze this in order to come up with Bill C-26 and determine that there were very particular needs having to do with all these things? And my last question for Mr. Blaney, when you talk about the high-risk sex offender database, who is going to determine who is the high-risk sex offender? How will that proceed? Also, do you think that people should be satisfied to know that there is a database that includes high-risk sex offenders? Should we not try to get that high-risk offender off the streets instead of emphasizing the database at this point?
Thank you. Thank you, Madam Boivin. I mean, firstly, to your question as to why more reforms, why more sentencing changes, particularly mandatory minimums, the short answer is we can't do enough to protect vulnerable children.
Did the others don't work?
They have worked, and the statistics demonstrate that the persistence of some sexual offenders gives rise to greater steps at deterrence, greater steps to arm our police, in many cases, our officials, with greater ability to deter. The use of peace bonds, for example, and having breaches of peace bonds or orders that have specific measures in place to deter child offenders being breached, we think that this is an important step to take as far as, again, sending that message of deterrence. Longer sentences, I would simply say that there has still been, in my view, when it comes to the damage, the harm that flows to a child as a result of a sexual assault, I think that the sentence ranges are still low in many cases, particularly for the high-end offenses that involve abuse of children. But I would also...
Is it your statement that the judges do not tend to go closer to the maximum that are provided, that they're too low sentences?
Well, there's still a range,
Canada?
and I would say that the lower range is what I'm concerned about, which is why mandatory minimum penalties are part of this package. But as I mentioned in my opening statement, it goes beyond simply the criminal justice system meting out higher sentences. It has to be approached in a way that we are putting what I would describe through the child advocacy centers as more wraparound support for a child, for their family, and for the community as well. The community has to be involved too. But this is part of the response that we feel is necessary. And when we look at that very sad statistic of the number of sexual assaults that are still occurring on children, and the fact that 55% of all sexual assaults reported are on children under the age of 18, this is an alarming statistic in a country like ours, and it begs for further response.
And often by a member of their own family.
One more
so
minute,
it'll be
including the
interesting
answer.
with the register. So maybe we'll move to Minister Blaney. How is your register? Who's going to determine le délinquant dangereux?
Are you going to determine how a sex offender is high risk? And what do you think of the fact that it's more often than not members of that family, of that children's family, who are the sex offenders? Thank you for the question. As you know, essentially, it's local police forces that determine who should be called high-risk sex offenders, and it's already done across Canada. No, I'm not saying who's going to notify, who is going to determine the status of high risk for a sex offender. Who's going to do that, and what criteria are going to do that by? Well, as I already said, local police services already notify the public of the high-risk sex offenders, and it's going to be that information that we're going to bring together and put up into the high-risk sex offender database. And the criteria, well, it's whatever criteria is determined.
The questioner is from the Conservative Party, Mr. Decker.
Well, thank you, Mr. Chair. And just before I turn to the ministers, Mr. Chair, I'd just like to refer to something that my colleague, Madame Boivin, mentioned. She took the time to ask Minister MacKay about the amount of time that this committee would take to study Bill C-26, this bill that we're studying today. And of course, she'll know that we had a discussion at our committee on the agenda for this bill on how many days we would study the bill, and in fact it was the NDP that suggested 4 days, which is the time that we've allotted for the study. Now this, I just think because there are people watching today, they should know this is the kind of nonsense we often get from the opposition. They actually set the time that they think we should study a bill, and then they try to make it public that
Point of order.
we are somehow cutting the time for study of the bill short.
I'm interrupting you.
Point of order, Mr. Deckard. I mean, what's said?
Mr. Decker doesn't answer the point of order. I do.
Our subcommittee was in camera.
That's
I just asked if the minister had any. I didn't say anything about the committee or anything.
Okay.
If you remind, if he wants to go into what went on the committee, I have no problem.
Right.
I'll have fun saying.
I appreciate that.
Four bills, one study in 11
I appreciate
days.
that. You only have an hour with the ministers.
Right.
Let me be clear to committee. We are going to talk about the subcommittee on agenda and the time allocated to this after we're done with the ministers, unless you want to waste time doing it now, and their hours up, whichever you prefer.
At any rate,
let's move on. Thank you, Mr. Beck.
My colleague understands that it's not the ministers that determine how much time the committee decides to spend on any particular matter, and I just think that people should know that there has been no attempt by the government side to curtail the study of this bill. In fact, you know, ministers, you should know that we think this bill is very important, and we want to spend a significant amount of time, an appropriate amount of time studying this bill. So no one should be under any apprehension that the government side has been trying to restrict the time for study of this bill. Minister MacKay, I'd like to start with you. You mentioned that there is more to addressing the issue of child sexual offences, which are on the increase, unfortunately, in Canada. I think that's a great tragedy, than punishment. The opposition often likes to point the finger at our side of the House of Commons and say we're all about penalties, and we're not addressing either prevention or the provision of services to the victims of sex offences and other offences. And you mentioned the Child Youth Advocacy Centres and our government's support for that. You'll know there's a very well-known centre in Toronto called the Boost Centre, which you visited, which does remarkable work in helping child sex victims. And you've also visited the William Davis Family Centre in Brampton, in Peel Region, the area that I represent, and we're very hopeful that a similar Child Youth Advocacy Centre will be established there in the Peel Region to serve sexual assault victims in Peel Region. I wonder if you could tell us more about those centres and our government's support for them, and how you think that can help address the issue of child sexual assault.
Thank you very much, Mr. Deckard. I must say, having been either a participant through the practice of law or through parliamentary work, a long-time observer of our justice system, I think this is one of the single greatest accomplishments that we have seen in recent years with these child advocacy centers, and the incredible compassionate work that they do at the earliest stage when the harm has been committed, when it is fresh, if you will. The approach that's taken by these child advocacy centers, you mentioned several in Ontario. I have visited these centers now in just about every province and territory. We now have 21 that are up and operational, with plans to bring about more. What it does, and the magic of these child advocacy centers, is bringing together all the various agencies and individuals that are working to support children, including the police, the court, victim services, child psychologists and psychiatrists, those who are tasked daily with helping to support young people deal with the trauma that inevitably flows from sexual interference and sexual assaults on children, and their parents and the broader community impacts as well. So that is something that I mentioned just to keep in mind with what you've said about taking a holistic approach to the harms that come from child sexual assaults that are on the rise. There's simply no getting away from that. And so this committee, I know, is seized of this issue. I would be very quick to point out the nonpartisan nature of this bill, and I think that that will become apparent as you look further into the detail. And yes, I fully expect, as I know Minister Blaney is, that you will give this a rigorous examination. And there are other things that we can do as well. And I had the opportunity to be in Madame Boivin's province just last week in both Montreal and Quebec City to see some of the programs that the Department of Justice also sponsors for young offenders who may, among other things, be involved in sexual violence and may be passing it on. This is a phenomenon that we have often seen, where they have been victims and then they go on to victimize others. So programs that are aimed at young people who are in the system, so to speak, and may benefit greatly from counseling, from programs, early intervention that will give them alternatives as they try to cope with the difficulty that they may have experienced. So that is accompanying intent that comes with this bill. I have information, Mr. Chair, about the child advocacy centres that I would seek leave, perhaps at the conclusion of our testimony, to leave with your committee.
Thank you, Minister.
Make sure the clerk gets it. That would be great.
Thank you.
We'd be pleased to see that, Minister. Minister, you'll know this bill contains some changes to evidentiary rules around spousal testimony, and because of the young nature of many of these victims, often the testimony of a spouse is important. Can you tell us about how this bill changes the evidentiary rules about spousal testimony and why it's important?
Yes, Mr. Deckard, it does very much impact on sexual offences in particular. I would suggest that in the past, where the competency and compellability of witnesses for the Crown for spouses did impact on the ability to secure convictions in cases involving children, where a spouse had very relevant evidence to present to the court but was prohibited from doing so. It wasn't a matter in some cases of the witness wanting to take the stand, but they were prohibited under the rules of evidence. This bill, in fact, has been overtaken in some ways by another piece of legislation that you're looking at, the Victims' Bill of Rights, which also has provisions in that act that would essentially eliminate spousal immunity from testimony. But this bill, which was drafted around the same time, amended the Canada Evidence Act to specifically allow for spouses to be competent and compellable witnesses in sexual assault cases involving children.
Thank you.
And thank you, Minister, for those answers. Our next question from the Liberal Party is Mr. Easter.
Thank
the floor
you,
is yours, sir.
Thank you, Mr. Chair, and welcome ministers and support folks. I do have some familiarity with the development of the sex offender registry. I was a minister in 2002 when we got a federal provincial agreement to go forward with the sex offender registry, but I think it was 2 or 3 years after that before we finally got it, before the government finally got it into legislation. So there's no question. We firmly believe we have to do all we have to do to protect people from sexual crimes. But as I go through this bill, and I think the parliamentary secretary in part mentioned it, there's two sides to the equation. There's penalties, there's prevention, and there's also rehabilitation. And I know that's not possible in all cases. This bill seems to be, and this is not my regular committee, as you would know, this bill seems to me to be mostly about putting greater penalties more consecutive sentencing, those kind of things. You did mention child advocacy and the good work they do. Is there anything else that the government is doing that's going to, on the healing side and on the rehabilitation side, deal with this problem other than the increased penalties and consecutive sentencing? Is there anything proposed in this bill that will do that I haven't spotted?
I may begin to answer, Mr. Chair, by mentioning that at Correctional Service Canada, when an individual, an inmate actually who's been convicted of a sentence related to sexual harassment, or even more importantly, a sexual offense, he is taken in charge by the service and offers some program. In all correctional jurisdictions in Canada, we are providing rehabilitation services to individuals convicted of sexual offenses. Treatment services typically involve group counseling aimed at psychological risk factors, and there are also medication that is part of it. So there's, I would say, psychological service and medication offered that are selectively used to manage compulsions and to lower sexual drive. And research have shown that comprehensive treatment programs can be expected to reduce the sexual recidivism rate of child molesters from 17 to 10% after a 5-year period. So at Correctional Service, there are a program offered while the inmate is serving his sentence. That's as for the what happens once the individual is convicted of a sentence.
I'll come back to Minister MacKay. I know he's working on an answer to the first question, but Minister Blaney, one of the big areas, and I think we all know that eventually these individuals come out of the correctional system, you're well aware of the program Circles of Support and Accountability, which Steve Sullivan, who's the director of October Victim Services, spoke at another committee I'm at about. And I'll just quote what he said. If Circles of Support and Accountability loses its funding, communities will be put at greater risk. It is the only community program that stands between the most dangerous offenders and their children. It has saved countless children from violence and terror, end of quote. That program has been virtually, the funding has been cut by your government, and the reality is, and I'm not going to get into the long explanation of what those volunteers do to work with high-risk sex offenders when they come out, but they have saved countless families from sexual violence. Why is the government not continuing to fund that, and will you reconsider so that we can build on the rehabilitative side? Because we have to deal with all areas, not just penalties.
Mm-hmm. Well, thank you for your question. Indeed, yes, we are working with many national voluntary organizations once the inmate have served their sentence and they are back in released to the community. It includes the John Howard Society, the Canadian Association of Elizabeth Fry Societies, the Salvation Army, the Seventh Step Society of Canada, and the St. Leonard Society. Indeed, the grants we had in place was providing a total of $1.1 million annually in the form of grants. Actually, it was provided to 15 organizations. We have provided funding until 2014. Now we are evaluating the funding on this initiative. We are reviewing it. I'm expecting some feedback from my departmental official. But I must tell you, it is important that we be there at the different step. But also, I would say it is important to send a signal that there's a tolerance zero for attacking child. And that's also what is behind this bill, not only for the child in Canada, but also from the child abroad. And this is why I strongly support Minister MacKay to impose a mandatory minimum sentences, because this is a crime that has to be clearly stated for what it is, despicable and socially unacceptable. And as you know, we are putting measures in place with the fact that if an individual who's been convicted will be traveling abroad, even for short times, he will have to report to the authority, and the information will flow.
Mr. McKay, or Minister McKay, do you have a quick answer?
Yeah, very briefly, Mr. Chair. Just in response to the question from Mr. Easter, there are programs, and Mr. Blaney mentioned a number of them. One that I'm aware of in Atlantic Canada is the New Leaf program, and to be fair, this was a program that was also funded by the previous government, of which you were a member, and it's aimed specifically at helping to rehabilitate the offender. And so those program funding requests are reviewed annually across the country. But on the proactive side, the Get Cyber Safe program and some of the online sharing of information is something that I would always point to as well as part of the proactive approach. The sharing of information abroad is something that we as a country have to do more of. We need to be responsible for some of the perpetrators, sexual offenders, who go outside our country and go to jurisdictions where they don't have the same protections, where they don't have the same programs. Or they have laws that are lax that allow for some of these sexual predators, and we have them in our midst, who have gone abroad and carried on this horrible practice. There is Aboriginal justice programs that are also in place to support both offenders and victims. And I would point to our legislation, Bill C-36, that dealt with prostitution, also has program funding in addition to the legislation. So this holistic approach that you refer to is something that we're continuing.
Thank you, Minister. Thank you, Mr. Easter. Our next question from the Conservative Party is Mr. Wilkes.
Thanks, Ministers, for being here today. My questions are to Minister Blaney, if I may. In order for law enforcement to track child sexual predators, excuse me, predators, there must be a certain level of coordination between CBSA and the National Sex Offence Registry. Bill C-26 would heighten accountability by changing procedures related to the method of notification of absences abroad by registered sex offenders. Can you please elaborate on this portion of the bill, and what information will be shared between the National Sex Offender Registry and CBSA officials as a result of the amendments of this bill?
Absolutely. I think the member, being a former police officer, long-time serving RCMP officer. I am also very proud to sit with the member in this government. Well, indeed, that's it, Mr. Speaker. We want to have a better information sharing between the Canadian Border Service Agency and those who are in charge of the registry that is containing the name of sex offender. So all the following information on sex offender is collected on a regular basis, and the information that will be shared whenever it is finished, it will be all the high-risk child sex offenders. When a high-risk child sex offenders will be willing to travel around the world, no matter the length of his stay, the information will be transferred from the RCMP to the CBSA, and this is the given name and surname and every alias that they use, the date of birth, the gender, and the number of every valid driver's license and passport that the individual may hold. So these are planned to serve as flag for CBSA, so they can eventually be diverted to a secondary screening when they re-enter the country, and they will have to provide some information to the border service officers, such as when have they left, when they are returning, and every address or location at which they have stayed outside Canada. And this information will be sent back to the National Sex Offender Registry. So it makes sure that if an individual has been identified as a high-risk child sex predator, there will be an ongoing build-up of information related to his traveling, and if whether the CBSA or the RCMP has reason to believe that it is necessary to carry this information from a specific sexual offender to the authority, they will have the authority to do so in order to prevent or investigate a crime of a sexual nature.
Thanks for that. And carrying on with this, the same theme, Bill C-26 authorizes disclosure to the CBSA of information from the sex offender database. Among other things, the CBSA will be authorized to provide the following information to the database regarding the sex offender who is the subject of disclosure: the date of their departure from Canada, the date that they return to Canada, and every address or location at which they have stayed outside of Canada. This provision will enable the CBSA to flag high-risk offenders in its surveillance system and to help the police ensure respect for traveller identification requirements. Can you please describe how the system currently works as it pertains to sharing of information between the National Sex Offender Registry and the CBSA? And can you use an example of how changes in this bill will help keep Canadians safe?
Well, the current situation is fairly straightforward. Since CBSA is not a law enforcement agency, they cannot share information with the registry. So this makes Canada blind whenever a high-risk sexual offender could travel across the world. And if I can make a parallel, we have a little bit the same situation when we have terrorists traveling abroad. Canada cannot become a net exporter or terrorist, nor of a sexual predator. That's why we need to enable our own federal agencies to be able to share information. So either in the case of terrorists, or in this case today, a sexual predator cannot take advantage of the gap we have in our legislation. That's why I'm fully supporting the initiative of Minister McCain. We're seeking your approval this afternoon to get this bill move forward so that we can close the gap and make sure that those who would take advantage of the lack of communication that is forbidden in the law is now of the past, so that if anyone is willing to leave the country to commit criminal offenses, such as sexual offense, well, this information will come back into the country.
Thank you. Further to that, Bill C-26 would heighten accountability by changing procedures related to the method of notification of absences abroad by registered sex offenders. Can you please elaborate on this portion of the bill? How does this reporting system work now, and how would Bill C-26 change the status quo? And would this amendment have implications with regards to our responsibilities to cooperate in international investigations?
Absolutely. Well, the bill will increase our capability to respond to our international responsibility and agreement we have in order to fight this plague that is sexual tourism. So this is really setting up the base. So a while ago, we set up our national sex offender registry. Now we have to make a better use of it. In this registry, we have identified a high-risk sexual predator toward child. It is important that we take action, and that's why with this bill, the flow of information between CBSA and the RCMP will be bi-directional. So when the high-risk sexual offender is leaving the country, the CBSA will be notified by the RCMP. When the individual will come back, CBSA will collect the information on the exact data of the traveling of the individual abroad, and these information will be sent back to the National Registry. So this back and flow of information will close the gap and limit the abuse some individual may have taken of our system of traveling abroad to commit sexual tourism. So that's why I believe this is a strong measure. The information sharing is one of the pillars of this bill, and a measure that will close this gap.
Thank you.
Thank you for those questions and answers. Our next questioner from the New Democratic Party, Madame Clay.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. I simply wanted to wish a happy new year to our committee members. I'm very happy to be back here with you in this wonderful new 2015 year. My first question goes back to what my colleague from Gatineau posed. Mr. Justice Minister, I want to know why all the offenses against minors were not included. You've increased sentences for a good number of offenses, but you haven't covered the whole gamut. How did you proceed with the selection process? How did you pick these offenses versus other ones that you didn't pick? What was your reasoning behind that?
The main criteria here were offenses against children that were of a sexual nature, that could lead to exploitation, that could lead to the type of harm that we felt could be best addressed by bringing about penalties that stress deterrence, penalties that put greater emphasis, in addition to some of the proactive measures that are found in the bill but have a more public safety component to it, sharing of information abroad, making use of the data bank and the systems that allow the public now to access that information as well, to take steps that they can put forth to protect their own children. So this is a modernization attempt, but the emphasis here were on offenses of a sexual nature against a child.
OK. Mais l'article 272...
But Section 272 of the Act says that a sexual assault, armed sexual assault, has a different. You've dealt with it differently. Is there some sort of exception to that?
My question is, Article 272 of the Criminal Code is the infraction is agression sexuelle armée, menace à une tierce personne ou infliction de lésions corporelles à un plaignant de moins de 16 ans. Donc, je voulais simplement savoir.
So I simply wanted to know why the bill. Why have you decided to go from 14 years to life imprisonment for that offense? As my colleague was asking, why did you decide to go from 14 years to life imprisonment under those circumstances and not in other circumstances? Why is it that in other cases, for example, why have you included this particular offense and not others? What was the general thinking around what you picked and chose?
Examine that particular section of the Criminal Code. We're talking here about sexual assaults involving weapons, involving causation of bodily harm. So throughout the Criminal Code, as you would know, there are sections that are deemed to be more serious, and thus a commensurate higher penalty would attach. Many of the sections that did not result in the elevation were already at the 14-year maximum penalty. And so for this particular offense and the nature involving the violence, the harm, the presence of a weapon, we deemed this to be commensurate with a higher penalty.
Okay. I understand. Thank you very much. Ma deuxième question, Monsieur le Ministre.
My second question, Minister Blaney, came to me after you answered a question from my colleague from the Liberal Party. You said that the database hadn't been budgeted for yet, so we don't really know what the costs would be. And when you answered my colleague's question, you said that it would be the law enforcement agencies or municipal authorities, whoever it is who's responsible for putting in place such a database. So my question is, who will determine and how are you going to determine the costs associated with this database, especially when we know that the authorities responsible for dealing with criminal cases have a hard time upkeeping such a database. That's why we have certain people who are still on the streets because their case file hasn't been updated. So how do you expect agencies and authorities who are already so heavily burdened to put in place yet another database when they don't have the necessary resources to take care of things usually? Well, thank you for your question. First of all, there is already a notification procedure to the public by provincial and municipal authorities. as we speak, there are law enforcement agencies who are identifying high-risk sex offenders, and these law enforcement agencies determine that in order to protect the public, that information must be made public. That procedure uses resources already in place. And if this bill is adopted, well, we're going to take the information from all those efforts across the country and put it together. And the agency that's going to take care of putting all that information together will be the RCMP. So that information is going to be collected, and following consultations we're going to be leading with provincial and municipal authorities, we are going to take from those public notifications that might affect crimes that are not sexually based necessarily, to focus specifically on the high-risk sex offenses and put it on a public database. For this pan-Canadian public database managed by the RCMP, there is a budgetary measure of $1.3 million per year for the first 5 years and $1.7 million for the subsequent years. There's also an amount that's budgeted, since there's going to be a necessary notification to be done to the CBSA, that goes up to $169,057, and this is the necessary amount to help the CBSA collect the necessary information in order to feed it into the high-risk sex offense database, for example, when they come back from their travels.
And final questioner of the ministers is Mr. Seaback from the Conservative Party.
Great. Thank you very much, Mr. Chair. Minister MacKay, I wanted to talk to you about a couple of things. I noticed as I've gone through the bill, we are working on a number of provisions that are going to increase some of the mandatory minimum penalties. We've got some evidentiary reform as well, and we're also looking at some consecutive sentences for child sex offenses. I think a lot of that's getting the coverage in the media, which is important, but some of the things that aren't really being talked about is when we look at the sections that deal with what happens in the penalties proposed for breaches of probation orders, prohibition orders, or peace bonds. I noticed there's some significant changes there that will have effect on sentencing, and I wonder if you could comment on that.
Thank you very much, Mr. Seaback, and as someone who practiced criminal law, you know that for years this has been a problem. Not only, and I suggest Mr. Wilkes as well, would know that dealing with consecutive penalties, mandatory minimums, maximums, etc., is very much part of this bill, but we have seen for years problems with conditions of probation, conditions of peace bonds or recognizance put in place as a preventative measure or a proactive measure to try to protect the public first and foremost, but to allow some modicum of control of behavior, so prohibitions on drinking or possession of weapons or being around a child. The history and the statistics will bear out that sadly the vast majority of sexual offenses against children happen in a dwelling house by a person known to the child. And so putting parameters around access to the child is what many of these preventative measures are intended to do. Now sadly, these conditions are routinely breached, and there, in our opinion, has to be some consequence to that, and that's what we're seeking to do here, is put in place through this bill increase penalties for breaches of probation orders or peace bonds, having real consequences, particularly when in concert with the breach of probation it actually results in another criminal offense. And so these breaches were very often treated as just part of the, unfortunately, the nature of the business. We'll just add that on as a concurrent sentence. There would be no specific recognition of that when a sentence was meted out by a judge. And so this attempts to change that. It ups the ante, if you will, for the maximum when it comes to the breaching of these particular measures. And the general rule that these offenses, depending on whether they're prosecuted by summary or indictment, is reflected in the seriousness and the impact of breaching those types of conditions that are meant to prevent further offenses. And so that's captured in this bill. It is an important part of the message that we want to send to the public, to offenders, and that these conditions are serious and are to be abided by.
You sort of started talking a little bit about one of the other things I wanted to ask you about when you look at concurrent sentences versus consecutive sentences. I know that's another change that's coming along with this bill. What was the thinking or rationale behind changing some of the process with a concurrent sentence versus a consecutive sentence?
Well, we have seen how this works at the very high end of the criminal code with respect to first-degree murders, and most recently the tragic shooting death of members of the RCMP in Moncton was an example where consecutive sentences, so to be clear, that means stacking one sentence on top of the other. They're not to be served concurrently, but one after the other, to denote that a crime was committed against an individual of a separate nature in each and every case. The same is certainly true of these sexual offenses against children. And the parameters around this are curtailed, rightly so in some cases, by this long-standing application of proportionality. But it is very difficult for a victim or a victim family member to hear that their sentence isn't individually recognized in the penalty that a judge is meting out. And so consecutive sentences do that. Consecutive sentences put particular emphasis on each individual crime, each act of violence and sexual violence against a child, we believe is deserving of a consecutive sentence. And so that is what we attempt to achieve through this legislation. And we believe that it's appropriate, given the simply abhorrent nature of this type of crime, the damage that is done, the loss of innocence, as my friend Minister Blaney has said. This is very important in our view to demonstrate to the public and to offenders the seriousness in which the justice system will respond to this type of heinous crime.
Thank you very much. That is our time with our ministers today. Thank you, both of you, for coming today and speaking us to 26 as we kick off the discussion and debate on that. We'll suspend for about a minute while we let the ministers go and change. I think there will be a discussion on the sixth report that is in front of us. I expect that to be in camera, just so people
Mr. Chair,
know.
just prior to suspension, if I might, I offered to leave this information on Child Advocacy
You
Center.
give it to the clerk, he'll submit it to all the members of the committee. Thank you very much.
Thank you.
Suspend for a minute. I'm going to call the meeting back to order. We're going to start a new meeting, but there has been a discussion. I need a motion to go into camera to talk about the sixth report. It's the agenda report.
Oh, okay.
It's been moved? Okay,
Yes.
so we're going to go into camera for a few minutes. All
We
those
could
in
do it.
favor?
We could do it at the end, though. We not?
Well, no. Let's do it right now.
Okay.
So we need anybody who is not allowed in here in camera sessions needs to. We won't be too long, I don't think. We'll make sure we get you back here as soon as possible. Thank you very much for joining us. Who is starting this off? Carol, are you? Who's? Oh, there's no opening statements, just questions. Oh, very good. Well, thank you very much for our witnesses from the Justice Department and from Public Safety. So, who would like to start with questions from the Conservative side? Oh, we were starting. Sorry, Madame Aubin.
Excellent.
Wonderful. Thank you very much. Considering we have a bit of time with you, public servants of both departments, as well as representatives from the RCMP. We spoke at length with the ministers about the increased sentences. I wanted to know if you, Ms. Morancy, before you moved ahead with Bill C-226 over at the Department of Justice, if you looked at case studies of things that have been happening over the last few years, both ministers said when they were promoting Bill C-26 that offenses against children had increased by 6%. We've heard that statistic constantly, both in the media and through those two ministers. How did you analyze things? What kind of analysis did you look at? Have you seen documentation that says there's a general sense that the courts have not sentenced enough? How do you get to drafting a bill like Bill C-26? What kind of studies did you look at before you got to these measures? Thank you for the question. As the minister said, we drafted Bill C-26 to increase both minimal and maximum sentences. If I may continue in English.
Proposing some other related reforms that are looking at the implications for consecutive and concurrent sentences in these cases as well. So as you've noted, Bill C-10, the Safe Streets and Communities Act, those reforms came into force August 9th, 2012. And yes, it is a bit, 2011, my mistake. It is a bit early to see some of the progress of some of those cases as they start to work through the criminal courts. But we are seeing courts beginning to note, for example, even before C-10 came into force, that Parliament was considering the importance of ensuring that the penalties in these cases, not just minimums but maximums, adequately reflect the serious nature of these cases and that courts should be treating these more seriously. So it is a bit of a combination of things. One, it's looking at how are the courts dealing with this. We're starting to see some of that, but it's certainly short. It's early days still, but we're seeing some. Secondly, it's an effort to have if you look at C-26 together, it's a combined approach in terms of trying to increase overall the penalties, not just the minimum penalties and coming up with that approach that C-10 had.
But I understand all that, but my question is more on what type of studies or constat did we have to see the need to create C-26? If we're not yet even able to see the effect, good or bad, of C-10, how can we see a need for C-26? So that's what because what I'm hearing from the legal community, I'll give you an example. Last weekend in my region in Gatineau, there was 50 cases of drunken driving that were thrown out of court. Why? Because of time, because the Crown didn't understand, according to certain people, didn't understand the case, the shift that happened with the new infraction, the new burden, and so on and so forth. Do we take the time to inform all the courts of all the changes so that they apply it before we come up with some new section, new clauses? I'm just not seeing the logic behind it all, because you're not giving me the meat. From your answer, I don't see exactly what was used to create C-26.
Well, again, I can just point to the commitments that the government has made, and that the minister has clearly stated that The overarching concern and intention is to ensure that in all cases, all forms of child sexual abuse are treated more seriously. Some reforms were enacted through the Safe Streets and Communities Act. C-26 takes that and goes further to achieve that objective. And one thing I'll note in particular, so C-26 increases the maximum penalties for quite a number of offenses, so you have a bigger range for courts to look at, which is different than what you saw in C-10.
So it's more in principles, but we're still not yet at the point where we can say what the other clause were able to achieve if it had a deterrence on criminality or whatever. I understand that.
Sorry, if I might, just on that point though, but another important thing that C-26 was proposing to say, if you look at the case law and how courts are dealing with sentencing now in cases where you have child pornography as well as a contact sexual offense, C-26 is saying ensure that those are imposed consecutively we're seeing that happening in some cases now. It's a matter of codification in many respects, but it's saying do that in all cases, and that's an important change that we don't have to this point. Similarly, the other reform that C-26 is proposing, if you have one offender before the court at the same time with multiple victims, again, very clear direction to the courts on how to deal with sentences between those multiple victims so that, as the minister said, each victim feels that their victimization is reflected in the sentence that is imposed on that offender.
So why in C-26, but it was not thought of in C-10?
I can't comment in terms of between then and now. C-10, as you'll recall, was an amalgamation of 9 bills that had been before Parliament over a course of some of the parts over several years, and were merged when in support of a government commitment in terms of after the federal election. So it was a reenactment, a reintroduction of reforms that previously been proposed. But if you'd like, I can ask my colleague, Ms. Levman, to give you examples of a couple of cases where we've seen courts beginning to take the very serious direction that Parliament is giving to the courts to treat child sexual offenses more seriously.
Well, I wanted to move to the RCMP, but I take notice that there are some good cases that shows that they were before even C-26 came into effect, that already are showing that the courts are taking more seriously the cases. RCMP.
Van, that's your 7 minutes there.
Okay.
Thank you very much. Our next questioner is Mr. Calkins from the Conservative Party.
Thank you, Chair. My question, I think, will be primarily for the members of the Royal Canadian Mounted Police. I have some questions dealing a little bit of a technical nature, but just reaffirmation to understand that I'm reading the legislative summary and the legislation correctly. The Sex Offender Information Registry Act already exists. The changes that are being proposed now are quite significant in the sense that right now anybody who's in the sex offender registry does not have to notify if they're leaving the country. Is that correct?
They have to notify if they're gone for more than 7 days, but they don't need to notify where they're going to be, like details of their...
There's no details?
No.
So if they were to leave the country for less than 7 days currently, would they have to notify? And the legislative changes that we're proposing in this, or that are being proposed in this bill, would change that should they become law. Is that correct?
Well, it'll change it for those that are high-risk child sex offenders. So
just for the ones that are high-risk child?
Those that are high-risk child sex offenders will have to provide details for any stay outside of the country for any duration. Have to provide exact details of when they're leaving, where they will be staying, when they're going to return. For the rest, it's for any of the others, if it's 7 days or more.
Now, currently, if somebody is on this registry and they're going someplace other than their usual place of residence or whatever the case might be, for a period of less than 7 days, no notification needs to be given. If it's more than 7 days, or if it's less than 7 days and they want to change their mind, they have to do so 7 days in advance. Is that correct?
No, they have to do that if they're going to change their mind.
Right. And let's say somebody's going on a 4-day trip. They're not notifying anybody. They decide they want to stay an extra 4 days. They can't make that if the legislation passes, the legislation that's before this right now, they can't make that decision mid-trip, can they? because the way I read it is they have to make that determination at least 7 days prior to departure. Did I read that correctly?
Go ahead.
If travel plans change, then what they have to do is within 7 days make a notification that the plans have changed.
Within 7 days of the travel change.
Correct.
Correct. Okay, good. Now I have questions for you in regards to the high-risk child sex offender database, because this is a database above and beyond, or it's a different database than the sex offender registry. Correct? I think that's important for Canadians to know. We're talking about two completely separate data entities. Now, the high-risk sex offender database is one that would only contain information about the offender that would widely be made publicly available. Is that correct? Do I understand that correctly?
What it is it's a database that will capture, first of all, to be put onto that public database. The first step is that the person will have to already been the subject of a public interest disclosure by local authorities, by provincial, territorial, and local authorities, right? So if they've met that first test, so that they've already been identified publicly in a public interest notice, then as long as they also meet, and there can be public interest notices for people that are not just sex offenders, but for other kind of offenses like murderers or things like that, right? So if they meet that first step, then in addition, they have to meet being or will be qualified as a high-risk child sex offender as well.
Okay. So it says here that those who are found guilty of sexual offenses against children and who pose a high risk of committing crimes of a sexual nature, those are the ones who qualify for that. Who makes the determination as to whether they pose a high risk? How is that determination made?
Well, there's so again, it's if they've been already identified by the province or territory where they're residing, then there's going to be a process, but there's consultations taking place with public safety and the provinces and territories, as well as with us, to determine exactly what the criteria will be for being to meet that threshold.
Now, this database, unlike the Sex Offender Registry Act, will be publicly available. Is that correct?
That's correct.
And it's going to be maintained by whom?
By the RCMP.
By the RCMP. And everybody who's a parent or has a child, grandchild, whatever the case might be, will be able to access that database publicly. Is that correct?
That's correct.
And, all right. Thank you, Mr. Chair.
You have 2 minutes.
Well, I can pass my time on.
I got you down as a speaker. Okay.
If you're done.
That's fine. I'm good.
Okay.
Thanks, Bob.
Thank you very much, Mr. Calkins. I'd like to follow up on the question that Madame Boivin put to Ms. Morency, and she mentioned that Ms. Levman might be able to tell us a little bit more about some case law. My question has to do with the totality principle and how, in your opinion, it's been applied by the courts to the types of offenses that we see in C-26. And my understanding is that some of the cases that we're talking about are just very recent cases. I noticed some of them are 2014 decisions, for example, and I believe some of them might actually touch on legislation that was previously passed in C-10 or perhaps other legislation. So I wonder if you could. I'd like for you to comment, Ms. Morency, and then Ms. Levman, if you want to take us through some of the cases. And can you tell us whether or not the courts have been consistently applying penalties in all of these cases, or is C-26 actually addressing some of those issues?
Actually, I'll have my colleague, Ms. Levman, answer the two parts of the question. Thank you.
Well, as Ms. Morency said earlier, we are seeing cases involving child pornography charges, as well as contact child sexual offense charges. We are seeing that courts are more or less fairly consistently imposing consecutive sentences, not in all cases, but it seems to be a trend. Where we're seeing a little bit less consistency is in the multiple victim cases. Right. So courts take different approaches. Right. Sometimes they do a victim by victim approach, and the offenses that are against one victim will be imposed concurrently, but the sentences for each victim consecutively. In other cases, we are seeing that victims are being grouped by offense. So the sentences are being imposed consecutively by type of child sex offense, but concurrently as per victim.
So is it true to say that there is some inconsistency in the way these sentences are applied in different courts?
Yes, and you also asked a question about the totality
Correct.
principle. So we are seeing that courts are taking note when there are multiple convictions for different offenses that they would have imposed a lengthier sentence for one particular offense, but they're reducing it by a year or two in light of the totality principle.
Okay.
Very much. Thank you for those questions and answers. Our next questioner is Mr. Easter from the Liberal Party.
Thank you, Mr. Chair. Just on this last question, either Ms. Morrissey or Ms. Levin, with these increased penalties that are being seen out there, is it having any impact as a deterrent to these types of crimes other than just keeping people off the street longer? Or nothing you can tell yet? I mean, I'm one who believes in the rehabilitation side. If the objective is to keep people off the street longer, well, that's one objective. But keeping people off the street longer and not providing the program and letting them get out at warrant expiry is just a huge problem waiting to happen. So I'm wondering if there is a deterrent impact, if there's an intended deterrent impact on these longer penalties, consecutive sentences, other than keeping them off the street. Is there any evidence to show that?
I think it's well established in terms of the criminal code's approach to sentencing. The fundamental principles require courts to consider denunciation, deterrence, rehabilitation, etc. pretty clearly. There is much research out there over the years that talks about the different impacts that penalties may have, including whether mandatory minimum penalties have a particularly deterrent effect versus incapacitation and all of that. I guess it would be difficult to say in the short term based on, for example, reforms enacted since C-10 in the last 3 years, to point and say, here's a direct causal relationship between this and that. It's not to say, though, that there hasn't been a noticeable impact by even the sentencing reforms from C-10. So, for example, if we look at some of the cases that have remarked upon the fact that Parliament was in the course of reviewing proposed amendments to treat these cases more seriously, and noting that, and very clearly courts saying, Parliament has said we should treat these offences much more seriously denounce and deter these offences. So to the extent that we can point to this in the short term, I think there is some evidence to that in some of the case law.
Okay, thank you. Just coming to the RCMP and the different databases, the high-risk child sex offender database will be public. How will that be accomplished, and how does the information flow? If Mr. Jones is released, is arriving in Delisle, Saskatchewan, what's the operations? How this information will get out there?
You're asking specifically about the public database?
Yes.
Okay, so it's not an issue of the release. That's important there. The first step for the public database is that the local or provincial and territorial authorities will have to have made a decision to do a public interest disclosure about that individual. When that happens, that's the first step. So if in cases where the local authorities have come to the decision to do a public interest disclosure, then the second test will be does this person meet the criteria for a high-risk child sex offender? And as I mentioned earlier, that criteria is still being developed in consultation between public safety and the provinces and territories, because right now the provinces and territories all have their own sort of approach on how they determine whether or not to proceed with the public interest disclosure. So that development is ongoing as to what that criteria will be. But if the person then meets the criteria for the high-risk child sex offender, then they will be added to the public database.
Okay. In terms of this particular piece of legislation is beyond expanding our own sex offender registry, but it is a different database. Is there this kind of registry, public disclosure happening in any other country in the world? I think it does happen in some areas in the United States. And what's their experience been? Do you know? Can you give us an example? I mean, if my colleague wants to look into where this system is in place, where would we look? Go ahead, Kathy.
Thank you, Mr. Chairman. Certainly this type of public database is available in the U.S. and it's been in place for a number of years. I don't know how many states participate. Do you have more information?
No, we don't know how many states participate, but the evidence has shown there's a lot of public support for having a similar database. There are some concerns about making sure it's kept updated, that things like addresses are correct so that you avoid the wrong person being identified as a child sex offender.
Okay. Is it, I don't want to create work here, but is it possible to give us a 3 examples of states that have this in place? Would you know 3 states off the top of your head?
I don't, but we could certainly provide the committee if you would like.
Provide the committee, just so that in terms of our own research, we can get information from that area.
Certainly.
One of the big areas of concerns I have with these individuals is that some of them don't take programs when they're within the correctional service system. What do you do, or what happens when they don't take programming now? Do they just get to warrant expiry and leave?
Offenders that are admitted to the Correctional Service of Canada institution, are assessed as soon as they arrive, and they are either recommended for a low risk, a moderate risk if they're a sexual offender, or a high risk program. That becomes part of that correctional plan, which is now mandatory to have, and it's taken into consideration, of course, when they are considered for parole or for day parole, and that factors into the considerations that are considered. Also, some offenders will have a long-term supervision order at the time of sentencing if the view of the judge is that this particular individual may pose a risk or may not be as open to some treatment options and programs as other offenders might be, and as well, if they still pose a risk upon release, they can also have a peace bond, an A10 peace bond imposed on them, as any individual can. Doesn't have to be an offender necessarily.
No further
questions and answers. Thank you very much, Mr. Easter. Our final questioner, I think, Mr. Seaback. The time is yours.
I want to talk about the interaction of consecutive sentences and the totality principle. I don't know who should answer the question, but when you look at the totality principle with some increased mandatory minimum penalties and also the consecutive nature of sentencing, how do you see those things interacting with each other with some of the jurisprudence you've looked at? Are we going to move from, if there's 3 victims and they used to give, I don't know, 6 years would be or 4 years would be the sentence for one, and now you've got 3 that are going to be served consecutively. Will that turn that into 12? Is that going to run up against the totality principle, or will judges be looking at saying we're going to make 3 each worth 1.5 and therefore end up sort of right where you were before anyway? How do you see that based on the cases and other things?
What's It's hard to say definitively what would happen. I mean, it's left to the discretion of the court at that point how they're going to deal with the totality principle. Once they determine that, given on the totality principle, the combination or the whole sentence would be unduly long or harsh. But as my colleague Natalie Levman has said, there are cases that we have seen where the sentence on the individual offense is reduced in order to meet the totality of the sentence, as well justifying it with the proportionality of the sentences themselves.
Do you see that if you're increasing the maximum penalty, do you see as that potentially moving the envelope with the totality principle? Because to me, if the old maximum sentence was, for example, 10 years, and now it's 14, do you see that is that in your mind moving sort of the goalposts around the whole circumstance?
Well,
or what would be your opinion of that, I guess? Because I know you don't know for sure.
Yeah. For sure, it sends a message. It sends a message of denunciation of what the worst offender, the worst circumstance committing this offense should get as a sentence. So it does encourage to courts to turn their mind to say, the maximum sentence is higher, has been increased, and therefore turn their minds in those situations where you could qualify the offender as the worst offender in the worst circumstances. So there is definitely, in some instances, a move that we see in sentences.
I'm going to share the rest of my time with Mr. Wilkes.
Thanks. My question to the RCMP. So under the National Sex Offenders Registry, sex offender A travels to Italy. And I use Italy because I know I believe we have a liaison officer there. But how are we to confirm that sex offender A, who provides 3 addresses that he's going to stay at in Italy, actually stays at them? Do we have a working cooperation with other police forces in Italy, or for that matter, Europe, or are we relying on our liaison officer to do that for us?
Well, it's not quite that direct. So what the legislation provides is for us to share this information with CBSA. So first of all, in particular for high-risk child sex offenders, we'll actually have detailed information for less than 7 days. It allows us to share that with CBSA, allows CBSA on the return of the individual to do some verification to see whether the information they provided aligns, or what they learned from that, if that aligns with what the person provided before they left. But for us to share information with foreign officials, it can be done. It won't be done pro forma. It will be done sort of on a case-by-case basis when there is some reason to either advance an investigation or to prevent some kind of offences. So it's, and keeping in mind things like ministerial directives on information sharing with foreign law enforcement, privacy issues, and depending on the country, what the impact of providing information may cause. So that's that's generally how it would work. And you'd have to have something specific to do more follow-up than beyond sharing it with CBSA and doing verification of the data.
Okay, thanks.
Is that it? Okay. We actually have 2 minutes left. Somebody from the NDP would like to take the time? Madame Leclerc?
2 minutes, I will never refuse to talk, even if it's for 30 seconds. Well, thank you. J'aimerais simplement poser ma question.
My question, the minister gave us a few figures. It has to do with the database. There are already databases that exist in certain municipalities, whereas others don't have one. I'd simply want to know how much it would cost. He talked about 1.3 million over 5 years and so on. So I'd like to know more about the budget for this new database, and how are you going to collect and put together all this information, and how is it going to be used in the municipalities? I know there are databases used by certain municipalities, none in others. So I just want to clarify what the minister was talking about a little bit.
are not databases in municipalities, that sort of thing. So what happens on the, you're talking about the new database that will be created, the public-facing database. What happens right now is that at the local level or the provincial level, there may be public interest disclosures made, but it's not a database for as much as there will be a release made, a news release made to the public to say that this offender is in our neighborhood or whatever, right? So that's, that's sort of, there aren't these other databases that we'll be pulling in from. What the cost for implementing the legislation for us for the changes to this that we have to make around the sex offender registry and as well as the new database was 6.7 million for over the first 5 years, and then I think 1.17 ongoing is the cost that's the estimated cost for the implementation. So that includes the development of this new public database, which is separate from the National Sex Offender Registry.
If I could just add a point of clarification. So the National Sex Offender Registry database already exists, and in that database there's 36,000. So there's a single national database for people that have been convicted of a designated offense and required to register. Now, in the provinces, there are registration centers that it's set out in the legislation that exists today under the Sex Offender Information Registration Act that identifies areas where offenders would go to report and register and do their annual reporting in and reporting any changes to their addresses, driver's license, those type of things. They exist today. That's what populates and keeps the information in the NSOR database current, valid, relevant. So we do have an ability to understand where offenders are, whether they've changed addresses, those type of things. And it's also, that information is also used for doing queries to support investigations.
Can I? No, I don't.
That's it.
That is a separate database from the high-risk child sex offender database,
so
which will be created once this bill is enacted.
Okay, thank you very much. Thank you for those questions answered. I want to thank our witnesses from the Justice Department, Public Safety and Emergency Preparedness Department, the Royal Canadian Mounted Police, and Public Safety Canada. Yes, Ms. Morris.
Sorry, could I just make one correction? I misspoke on the C-10 reforms on the child sexual offenses penalties. They came into force, I think I said 2011. It was August 9th, 2012. My mistake.
Okay, thank you for that correction. Thank you for all your service to this committee and to the public. Thank you very much. With that, we'll be adjourned till Wednesday.
Thank you.